Good morning, everyone. All the CA Foundation students who are preparing for December 31st exam, that is CA Foundation exam 2023. I hope you're very, very busy preparing for exams, but I wanted to actually slightly and briefly revise law reference material that is given by institute. Understood. I mean, Institute of Chartered Accountants of India, that is ICAI, releases summary of the topics for every subject. So I'm just taking up. So because there are some, because whatever institute has given, we should actually go through. The reason I'll tell you, because when they have given so much of material, I'm telling you, out of all three institutions, ICAI provides you so much of literature. So much of literature, you have to first go through it. Maybe if the teachers have given extra material, that is a different story, but first you have to follow institute material, institute practice papers, institute practice manual, so many, whatever has been provided by institute, I advise you to go through it. Okay, so I just wanted to discuss few case laws actually here, because I wanted to guide you as to how to exactly you have to answer this CA Foundation law paper, because the CA Foundation existing syllabus law paper is for 60 marks, and 40 marks you have got business correspondence report writing. So this law actually plays a key role. I'm telling you guys, if you know how to actually present it, you don't have to present exactly how others are presenting, but I'm telling you, if you follow simple tips, small tips while presenting the answer, I'm telling you, easily you can score 40 to 50 marks. Trust me. If in case you have a language grip, and you, though grammar and grammatical mistakes might not be very important here, but I'm telling you, you should be able to present the concept properly. Okay, so let's look at some basic concepts. I'm assuming that those who are listening to this class, you already know something in law. So if you are attending for the first time, this will not help you. I'm telling you, if you have already understood some concepts in law or basics, fundamentals you already had, and you completed reading the syllabus once, and this is going to help you, and very nice it is actually. So only thing is how to use it, you should know. So for all the subject, reference revision material is given by ICAI. Okay, so let's look at this. So we have this from the first chapter. We have business laws may concepts related to entering of a contract under Indian contract. So this syllabus. First one, you have got Indian Contract Act 1872. First one, you have got Indian Contract Act 1872. Yes, in that basically we have three concepts called agreement, contract, offer and acceptance, etc. Okay, so in general, an agreement is nothing but an understanding between two persons. But when it comes to law, in a juristic way, agreement is nothing but offer and acceptance. Offer is nothing but willingness of a person to do something or not to do something. Acceptance is nothing but giving a consent. So when there's an offer plus acceptance, this will become an agreement. If that agreement is enforceable, that will become contract. That means every contract is an agreement enforceable by law, but every agreement may not become contract, because an agreement to become contract, it has to be enforceable by law. So if you look at let us go by the material what is given. So you knowing the subject, I knowing the subject, that's a different story, right? Look at this. It is law defines the term of when one person signifies to another his willingness. So that means it clearly says a person has expressed his willingness to do something or not to do something. Doing something is nothing but, in law, when you want to express doing something, we express it as act of doing something. And when you want to express that you don't want to do something, then we express the word abstaining from doing something. That means when one person signifies his willingness to do or not to do something, the word not to do, you can understand in the subject language as to abstain from doing something. So offer is willingness of a person to do something or not to do something. And next one, it says his intention should be to obtain the consent. His intention should be to obtain the consent. Okay, consent or assent we can say, right? Next one, to such act or an abstinence. So overall, offer is a willingness of a person to do something or not to do something with the intention of obtaining the consent from other person. That is what it says. Next, if you look at the left hand side, it says, say for example, A agrees to sell car to B on payment of price. That means A has an obligation to give car. So obligation is created and he has a right to receive a payment. So this chart clearly tells us every agreement creates rights and obligations. And these rights and obligations are actually created by parties only. These rights and obligations are created by parties only. Similarly, B has a right to receive the car on payment and B has the obligation to make a payment. So this chart clearly tells us every agreement creates a right and obligation. Got it? That is one thing. So if you look at this clearly, requirement for an agreement to be a contract. If you want to make the agreement as contract, what is the requirement? Section 10 has given 10 essential elements. As you all know, Indian Contract Act of 1872 has given 10 essential elements. So some of the elements have given here. So number one, if you want agreement to be contract, there should be free consent, in the sense none of their consent is forced. There should not be any fraud. You must have heard about it, right? And both of them must be competent. Number one, there should be a consideration. Consideration means something in return. And the objective, the purpose for which they have come to an agreement must be lawful. And the agreement should not be expressly declared by law as void. Agreement should not be declared by law as void. So section 10 is trying to give you, actually in our regular syllabus, we have got 10 essential elements that should be satisfied if you want to make the contract valid. So contract is an agreement enforceable by law. Agreement is the offer plus acceptance. Offer is the willingness of a person to do something, and acceptance is nothing but giving a consent. All right. Now, if you look at the next one, section 10 is not complete, exhaustive. So there are certain other sections which also contain other requirements of the contract. Okay. Not given by section 10, but also considered as essential. That means over here in section 10, what is given? There should be free consent. Those points are there, capacity to contract, etc. And other essential elements, miscellaneous essential elements, if you see, there must be two parties. One party must be the offerer. Offerer is a person who makes an offer. Offeree is a person to whom the offer is given. And the next one, both the parties must have created a legal relationship. In law, when we talk about legal relationship, if in case something goes wrong later on, both the parties must be in a position to take a legal action against each other. When I say creating a legal relationship, you are serious in taking action against each other. Then we have got legal formalities, like some contracts, like house contracts, etc. There must be a legal formality to be satisfied. Legal formalities are nothing but maybe some agreements require documents. Though contract can be entered, agreement can be entered orally or express way or written way, anyway, but there are some contracts which must satisfy some essential elements. So legal formalities and certainty. When you make an offer, it should be clear. That means it should not be on the basis of an uncertain event. Though there are some exceptions, we'll see them later. But when it comes to certain contract to be valid, there should be certainty. That means A promises B that he would like to sell 10 liters of oil. There is no certainty as to which oil. So therefore, there should be certainty. Next one, when A makes a promise to B, it should be possible. That means A cannot make a promise to B that he will get stars from the sky. If in case A made a promise to B that he is going to get stars from the sky, it is not possible, it is impossible. Therefore, it will be treated as impossibility and the contract becomes void. I'm going according to exactly what institute has given. So when institute has given 100%, there will be logic behind it, and they definitely expect students to go through it. But you can also go through. I'm just revisiting and revising so that you will be able to have a track of this concept. That's it. Then next one. So every contract needs to have a agreement, and every agreement needs to have an offer and acceptance. I repeat, every contract needs to have an agreement, and that should be enforceable, and every agreement should have an offer and acceptance. Yeah, it's simple. Yeah, it's a recorded class anyway. If you think that I'm going fast, you can go back and rehear it once again, right? There's nothing wrong in going back. You can't say, oh, this man is very fast. I'm revising. I'm revising to the students who have already understood something in law. Then what is this proposal? It says proposal is a starting, I mean, offer in general, in law, we call offer as offer only, but in general, we call it as a proposal. So meaning almost will remain same. That means offer is nothing but a person's willingness to do something or not to do something. A person's willingness to do something or not to do something. Not to do something can also be called as abstaining from doing something or forbearance to do something. So right side you see here. They have given this, we have already discussed, right? Next, essentials of offer. So directly, so you may have one theory question, what is offer and what are the essential elements of offer? But one difference you have to remember, though it is not given in law, offer plus acceptance is agreement, but in general, proposal plus acceptance will be called as promise. In law, offer plus acceptance is agreement, but in general, proposal plus acceptance will become promise, and every promise or a set of promises will become agreement. That is the point, right? So essentials of, so when I make an offer, what basically I did, I expressed my willingness to do something or not to do something. When I made an offer, what did I do? I expressed my willingness to do something or not to do something. So he is asking a question, what are the essential elements of valid offer? What are the essential elements of valid offer? See here, it clearly says there must be at least two parties. Yes, there must be a person called offerer, the one who makes an offer. Offeree is the person to whom the offer is given. The next one is what? An expression of willingness to do something. An offer can be doing something or not doing something. It is not compulsory when I make an offer, I should be doing something. I also can make an offer not to do something. And next one, very important essential element, when you make an offer, when the other party or other person is trying to give a consent, you should be able to accept it. You made an offer, but other fellow is giving an acceptance, but you're not accepting it, then there is no use. So that means you must be serious in obtaining the consent. That is those 3 points. Next one, mode of offers they have given. Tell me, how do I make an offer? How do I make an offer? Can be made by an act, in the sense doing something. Omission or abstinence, not doing something. I made a promise to you that I would like to drop you, and I made a promise to you that I will not trouble you. Simple example. If in case I made a promise that I would like to drop you at your home, that is an act. If in case I made an offer that I will not trouble you because I've been troubling you, if in case I made an offer that I will not trouble you if you give me this one, that could be abstinence. Abstinence means stop doing something. Stop doing something. So this, how do you make an offer? It says very clearly you can make an offer by words spoken or words written. So it can be oral or written form. It can be by the conduct. When the offer is made by your conduct, by your body language, you don't speak anything, you don't talk anything, you don't say anything, but you show your body language to the other person that yes, this is so and so. Yes, you are willing to do something. When the offer made by a person by conduct or a behavior, it is called implied offer. You must have heard. It is called what offer? Implied offer. The point clear? Finish. I said very clearly, I'm going according to I say. This lesson will help a student who already had attended classes in the classroom or who has already studied something in law, understood something in law, just because you are a student. End of the day, you are a student. I'm a teacher, you are a student. I can remember, but you won't be able to remember. That is why you are called student. So there is nothing wrong in last minute just rehearing something, so that if that question comes, you can nicely put it on the paper and write something and improvise your answer, right? That is what my objective generally. All right. Yes or no? Very good. Just a second, please. Yes. Yes. Okay. Next one, you see classification of offer. He's trying to, so when A made an offer to B, when A made an offer to B, when A made an offer. So in every offer, you will definitely have what? A, Mr. A must have made an offer to, Mr. A must have made an offer to B. Mr. A must have made an offer to B. So when A made an offer to B, these are the types of offers. See, one by one, we'll see here. Now, if you look at this carefully, general offer, the offer which is made to entire public. where anybody can accept. Specific offer, the offer made to a particular person where only that person should accept. Third one, cross offer. Cross offer is such a situation where both the parties have made an offer for each other and both the parties do not know each other's offer. I posted a letter, you posted a letter saying that you would like to buy my car. I posted a letter saying that I would like to sell my car. Both of us have made an offer for each other, but we do not know each other's offer. That means sometimes in ignorance of offer for each other, if both the parties have made an offer for each other without knowing, A posted a letter, B does not know, B posted a letter, A does not know, both the parties have made an offer for each other without knowing each other's offer. That is cross offer. It will definitely not become contract. The reason being it doesn't have a valid acceptance. Cross offers will not become a valid contract because it doesn't have valid acceptance. Then counter offer, A made, listen to my examples carefully. You are revising, okay? A made an offer to B that I would like to sell my car for 4 lakhs. And B says, I would like to buy your car for 3.5 lakhs. A says that I would like to sell my car for 4 lakhs. And B says, I would like to buy your car for 3.5 lakhs. That means B rejected 4 lakhs offer and he made an offer. The offer given by offeree, usually we call it as counter offer. And counter offer will be valid only if the offerer has accepted that counter offer. If the offerer did not accept the counter offer, it's not going to be a valid offer. Standing means remain open. Standing means remain open. So the offer which is made open, but it is not closed. Most of the government contracts and tenders will be in the nature of standing offer. Quickly, general offer is the offer which is made to entire public, anybody can accept it. Specific offer is the offer which is made to a particular person, only that particular person should accept it. Counter offer is the offer which is made by offeree, rejecting the original offer given by offerer. It will be valid only if the offerer has accepted it. Cross offer is the offer where both the parties have made an offer for each other without knowing each other's offer. Since there is no acceptance in cross offer, since there is only offer from both the sides, but there is no acceptance from both the sides or one side, we do not call cross offer as a valid contract. And standing offer is the offer which is made open but not closed. Most of the government contracts and tenders will be this type. Finish. I'm going according to ICAI. Okay, very nice. You guys are following very quickly. So this is given, you see, counter offer, standing offer, awesome. Explanation is given very clearly here. Yes or no? Now I'm going to read some case law. These case laws, because out of your 60 marks, there is every possibility 40 marks worth in CA Foundation law, practical case law oriented questions. Maybe you don't have to remember the case, you don't have to write the case name, but similar examples, cases, law questions they will ask you. I will tell you here, please listen to me carefully how to handle this. So whatever case that is given to you, it is like a problem that is given to you. Basically, in every case law, there will be a problem. You must be able to identify the problem and you must also identify the concept. And later on, you have to give a solution. So first important step that you have to do when the case law question is given, you read the entire case and come to a conclusion what exactly is the concept that is involved. Whether it is concept of consideration or capacity to contract or free consent or coercion or undue influence or fraud, misrepresentation, what exactly is the concept involved in this? Once you come to a conclusion that so-and-so is the concept, if you know the section, start your first paragraph with the section as per section so-and-so in Indian Contract Act of 1872. Consideration means so-and-so if consideration is the concept. So you have to first explain in 6-7 lines what exactly is the concept involved in the case law, that case. And later on in the second paragraph, 3-4 lines, you must be able to explain what exactly happened and what exactly is the issue. So second paragraph, you have to explain facts of the case. What exactly is the issue? And the third paragraph, finally, therefore, in the instant case, taking the above information into consideration, we can conclude that so-and-so is eligible, so-and-so is liable, so-and-so is to pay, etc., etc. That's how you have to write. So divide your practical question answer into 3 paragraphs. First one, the concept. If you remember the section, start with the section. If you don't remember the section, fine, but don't write the wrong section. But if you write the section, definitely you will have full marks. And the second important paragraph, you have to clearly explain what exactly is the issue in the problem. And the third paragraph, you have to explain very clearly what exactly is the solution. So moral of the story, never give answer in the first paragraph. Because giving an answer in first paragraph is like you are simply straight away giving an answer without even explaining and understanding what exactly is the concept involved. Otherwise, some practical questions, what do? They give a practical question. They give questions like 1 or 2 questions in 1 line, 2 lines answer questions they will give you. So one by one, you keep answering. It's finished. That is very simple. So let us look at this. Carlyle versus Carbolic Smoke Ball Company Limited. There is a case law. So the case law is Carlyle versus, there is a lady, Carlyle, Mrs. Carlyle, the lady. So first name is basically the person who actually complained, right? Plaintiff. The second name is basically the defendant in this, right? So in this famous case, I'm reading the case in front of you. Okay, in this case, this company advertised in several newspapers that a reward of £100 will be given to any person who contracted influenza after using the smoke ball produced by the Carbolic Smoke Ball Company, according to the printed direction. They said very clearly, whoever uses this and still affected by influenza disease, according to our instructions and directions, if you have followed, if you have used it, still if you are affected by that disease, we will give you a reward. One lady, Mrs. Carlyle, used the smoke balls as per the directions of the company, and even then she suffered from influenza disease. So this is a general offer, right? The offer is given, first of all, what is the concept into? Oh, it's a general offer. It is given to public in general. So just now we studied, no, general offer is the offer which is given to entire public in general. So this kind of an offer, and they gave very clearly, these are the instructions, these are the directions. If anybody uses this particular medicine using our directions, instructions, if in case still that person is affected by the disease, we're going to compensate. Bolke company has made it very clear, and company has made it very clear, and it is very serious also. And it's a general offer, anybody can accept it. So in the decision, there is a solution given, but understand now how the question. So you need to understand, that means in this case, company must have denied later on that we won't give you because we did not give you an offer. Then this lady filed a suit against the company. So it was held in the court. She could recover the amount as by using the smoke balls she accepted the offer. That means so in the first paragraph, what you have to do, this is the case of as per so and so Indian Contract Act 1872, an offer can be doing or not doing something, and it can be general or specific. And general offer is the offer which is made to entire public. In such case, anybody can accept it. That's what the concept in the first paragraph you have to write. So after writing first way, in the given case, Mrs. Carlyle has used the smoke balls, whatever medicine that is issued by the company, and she followed the directions. She's one person from the public. Since it is a general offer, anybody can be accepted. So Mrs. Carlyle has accepted the offer. That is what in the second paragraph you have to write. And the third paragraph, therefore, in the given instance case, she is entitled to recover the damage from the company. Yes. See there now what answer is given. So hence it was held that she could recover the amount by using smoke balls. And in terms of Section 8 of Indian Contract, anyone performing the conditions of the offer can be considered to have accepted. That means whatever conditions that company has given, she has followed. Until the general offer is retracted, withdrawn, it can be accepted by anybody. So that's what I told you. In the beginning, you have to explain what is this offer, what is this concept, what is the section involved. Then in the second paragraph, you explain what actually happened, what company is saying, what she is asking. And lastly, you have to say it was held, or in the instant case, she can claim because she has accepted. She is one of the person from the general public. It's a kind of general offer. Anybody can accept, and company is liable to pay. This is how my answer, your answer may not be same, but the concept clarity has to be same. No option, right? They might change the names and ask you this kind of questions. You should be very careful. Professional courses you must have less fun, more concept. Because these days across the country, what happens? Teaching lot of comedy is happening, concept is missing. When a lot of comedy is happening, concept is missing. Students enjoy classes, but unfortunately they fail in examination because what is going inside their mind is comedy. I'm not saying there should not be humor in the class. There should be a humor in the class because we teachers cannot teach you for more than 1 hour unless and until we bring in some humor in the classes. But humor should not dominate in the class. And personal biography of the teachers must not dominate in the class. What should dominate in the class of CA professional courses is the concept and the subject. And you must always start probing from your side. Do not expect everything from the student. Don't make the teachers a spoon feeding persons, please. That is very important because it may not be as you think. They try to twist example in a different way. So you must have understood the concept properly. I hope you got my point, right? One more question. Case law is Lalman Shukla versus Gauri Dutt. Gauri Dutt sent his servant Lalman to trace his missing nephew. He then announced that anybody who traced the nephew or his nephew would be entitled to certain reward. So Gauri Dutt sent his servant Lalman Shukla, and he said very clearly, he sent, but he did not inform Lalman Shukla, beta, if you find my boy, I'm going to give you a reward. After he sent, he made a general announcement that whoever finds, that's what, after he sent his servant, he announced, whoever finds my missing nephew, I'm going to reward them. Then see this point clearly. Lalman Shukla traced the boy in ignorance. That means Lalman Shukla traced the boy without knowing the announcement of the reward. That is the key point here. All right. Subsequently, when he came to know of the reward, he claimed it. That means after submitting the boy, he found the boy, he submitted the boy. After submitting the boy, maybe somebody would have told him or he came to know later on. Then he went back and asked Gauri Dutt, I want my reward. Gauri Dutt says, I will not give you because you do not know this reward before submitting the boy. So moral of the story, this concept is what? This is about communication of offer. This is about what? Communication of offer. Communication of offer. That means unless and until offer is communicated, communication means what? It should be brought to the notice of a person to whom you made an offer. If A made an offer to B, B must be aware of it. B must know of it. If B is not aware of it, B is not known about it, then how can he claim? How can he claim? It is not possible, right? And now in this case, what? Communication of offer. So briefly, you have to write as per section so on. So communication of section 4 is given now here. Section 4 is given already. Yeah, try to remember. There's nothing wrong in writing because if you write full marks, you will get, no, almost. If your answer is perfect, section is perfect, yes. And that 2-3 days away, you're away from exam now, what's wrong in remembering? You can easily remember. You don't decide not to remember, first of all. The problem with you is you will decide, sir, how to, how to remember. Don't ask that question. I know section 4. I know section 8. I know section 10. Like this, you have to remember. This is what is called focus. So this is about communication. So you should say, like, every offer should be, you know, rules of offer. You have got something called communication of offer. So communication of offer is complete when communication of offer is complete in 3 ways. If it is face to face, when he says it, it is complete. If it is letter communication, when offeree receives it, it's communicated. When it is letter communication, when offeree receives the letter, it is communicated. Receives the letter, that is general point. Afterwards, we have next advanced level, something called, okay, offeree received it, but he never read it. Then in such case, when offeree read it, communication is complete. Got my point? So first paragraph, so I understood, okay, it's about communication. Gauri Dutt is refusing to give him because, beta, you are not communicated. You don't know about this. So Contract Act also clearly says offer should be communicated. Offer is complete only when it comes to the knowledge of a person to whom it is given. So here Lalman Shukla doesn't have any knowledge of the reward. First explain about the communication. Second case, what you have to do, you have to explain very clearly in the given case, so and so happened. What happened? Lalman Shukla submitted the boy without knowing the reward of offer. That means Gauri Dutt sent Lalman Shukla without telling him reward. After he sent Lalman Shukla, he announced a reward, and Lalman Shukla is not aware of this. Then the third paragraph, in this case, we can say is not entitled for the reward because the offer which is announced by Gauri Dutt is not communicated. So first paragraph, communication related. Second paragraph, what happened in the case. Third paragraph, whether he's entitled or not. Do not start the answer, he's not entitled in the beginning itself. Try to explain first concept, etc. That's the last paragraph you must be able to explain. See this, it was held, but here for explanation sake, the revision sake, they gave you in the beginning itself. He was not entitled for the reward as he did not know the offer. Section 4 clearly states communication of proposal is complete only when that offer has come to the knowledge of a person to whom it is given. And in Lalman case, what happened? So this is the second. The nephew absconded from home. The plaintiff who was defendant servant was sent to search for the missing boy. After the plaintiff had left, the defendant means the person on whom the suit is filed. In this example, Gauri Dutt is a defendant on whom Lalman Shukla filed a suit that he wanted a reward. Announced a reward of rupees 501 to anyone who might find out the boy. The plaintiff was unaware of this, was successful in searching the boy, but he's not entitled. The reason being it was not communicated. Yes, understood now? Understood now how simply you can? Nice, no? This I see people are doing a fantastic job giving the. So when he came to know of the reward which had been announced in the absence, he brought an action against so. So that means after submitting the boy, he came to know that there is a reward announced. Then he came back and he started claiming. Then Gauri Dutt says, "I will not give you." The Lalman Shukla went to court and filed a suit. Court said you are not entitled because it was never communicated to you. And 1 year before CA Foundation exam, there was missing dog, missing cat, like this. Same story. Same story. Got it now? This is how you have to answer. I hope you are able to follow what I'm teaching. Next, one more case, Bolton versus Jones. Okay, let us look at this concept. It says it is Bolton had taken over the business of Brocklehurst, with whom Jones had previous dealings. So let us understand this carefully. So I'm explaining here. Bolton had taken, B has taken over the business of one Brocklehurst, with whom Jones had previous dealings. So here we can say who took over the business? See, Bolton had taken over the business. Bolton has taken over the business from whom? Brocklehurst, right? Jones had some settlement with whom? Brocklehurst. And this now currently, where is the business? This one, Bolton, right? Next, what happened? You see, with whom he had previous dealing. Jones sent an order for goods to Brocklehurst. So Jones thinking that business is still with whom? Brocklehurst. So he sent an order to Bolton in the name of Brocklehurst, because business was actually held by whom? Brocklehurst. So he doesn't know that Jones is holding it. That's the point. Next one, dealings. Jones sent an order which Bolton supplied without informing Jones that the business had changed hands. So nicely, what happened? This Bolton uncle, nicely supplied goods without informing Jones that business was taken over. Yes, next one. When Jones found out that the goods had not come from Brocklehurst, he refused to pay. So he came to know goods have not come from whom? Goods have not come from whom? Goods have not come from whom? Brocklehurst. Yeah. So it's like this. You understand overall. Brocklehurst is a businessman. It was taken over by Bolton. Okay. Jones gave an order to Brocklehurst, but business is supplied by whom? Bolton. So moral of the story, common sense you apply now. That means there was no contract between Jones and Bolton. There was no contract between Jones and Bolton. Actually no contract, but Bolton supplied. And Bolton did not even inform Jones that I took over the business. So Jones, in the original case, Jones had some money to be collected from Brocklehurst. Jones thought, if I buy goods from Brocklehurst, whatever money that was supposed to be paid by Brocklehurst will be adjusted. So that's how he ordered goods. Then Jones refused to pay. Then Bolton files a suit saying that you have to. So Jones says, I never made an offer to you. So, look at this. He refused to pay for the amount. What happened? Jones is not liable to pay for the goods. It is the rule of law that offer made to specific certain person, etc. Understood now? Here also what? You have to explain very clearly the offer not given to whom. So Jones had given a specific offer to Brocklehurst. Brocklehurst offer was offeree, but Bolton supplied. So Jones is saying, I never made an offer to you. So you have to explain offer, specific offer. Then you have to explain in the given case this happened. So therefore, Jones has never made an offer to whom? Jones has never made an offer to whom? Bolton. So therefore, Jones is not liable to pay to Bolton. Okay, you have to. So don't simply write that answer. You have to explain the concept and write. All right, guys. So this is all important case related to communication. And fifth one, you have something called difference between offer and invitation to offer. See, there are two things. A can make an offer in different ways. Sometimes what happens when A made an offer, he doesn't show his final willingness. When A made an offer, sometimes he doesn't show his final willingness. That means every offer has to show final willingness. If in case offer fails to show final willingness, 100% it's not going to be a valid offer. So are there any situations where final willingness is not shown? Yes, there are some situations like newspaper advertisement, it's not final willingness. Timetable is not final willingness. Catalog is not final willingness. Prospectus is not final willingness. It's not showing final willingness. Brochure will not show final willingness. Exhibited goods will not show final willingness. A casual information given will not show final willingness. There are many instances where even though it seemed to be an offer, but since he did not show final willingness, there is no offer. So moral of the story, an invitation to offer is not an offer as it does not show a final willingness. Sometimes a person also expresses an intention or his desire to say something. Suppose a person is saying, I'm thinking of selling my red color car. He's only saying, I'm thinking of selling my red color car. He did not finally express his willingness that he would like to sell his car. So intention to offer, invitation to offer, both will not show final willingness. Since both will not show final willingness, they're not offers. So there is a difference between invitation to offer and offer. Offer, invitation to offer, intention to offer will not be an offer. Invitation to offer, intention to offer will not be an offer. Is my point clear? So that means if an offer does not show final willingness, it's not going to be an offer. So you have to find out what is this intention to offer, what is this invitation to offer. Invitation to offer is like giving an advertisement, showing a catalog, giving an information, just giving an information, printing a prospectus, a brochure, etc. So these are all invitation to offers. Intention to offer means you express your desire. You did not clearly mention that you would like to sell. You say, I'm thinking of selling my car. I'm thinking of selling my house. That thinking only expresses your intention. It doesn't show final willingness. Since it does not show final willingness, it is not an offer. Understood? That is the case law here. Let's see now. In this case, Privy Council, those days Supreme Court, okay? Privy Council explained the distinction between an offer and invitation to offer. In the given case, the plaintiff, through a telegram, asked the defendant two questions. Plaintiff, through a telegram, asked what? Two questions. Will you sell us a bumper hall pen and give us the lowest cash price? And the defendant replied through telegram that the lowest. So that means he's asking information. He gave an answer for that information. That's it. So that means a casual information given or catalog given, booklet given, brochure given, prospectus given. There is just an information given to you, boss. It does not mean we are offering to sell. So later on, what does he says? Okay, plaintiff sent another telegram stating that we agreed to buy bumper hall pen. I only gave an information. I did not say that I would like to sell. However, the defendants refused to sell the property at the price. Plaintiff filed a suit contending that they had made an offer to sell the property, etc., etc. They have to. So remember here, in this entire case, what is happening? Offer is missing. On what basis offer is missing? Because the person who gave an information, he only answered 2 questions, and by answering 2 questions, he only gave an information. He did not express that he is willing to sell. So that means he never made an offer. So an offer should show final willingness. So in the second paragraph, what you say, therefore, in the given case, there is no final willingness because it was just an answer to a question which is asked. So therefore, there is no offer. So indirectly, invitation to offer does not show final willingness. This is an example. Therefore, in the given case, they only gave an information and is not liable to sell the goods. And for not selling, the other party cannot file a suit. That's how you have to explain. Got my point? Yes. One more case law I see. Mac person versus Appanna. The owner of the property had said that he would not accept less than 6,000 for it. It was held that this statement did not indicate any offer, but indicated only an invitation to offer. That means he said very clearly, I will not accept less than 6,000. But he only said, this is what I'm thinking of charging a price. This is what I'm thinking about the price. I'm not saying I would like to sell my property. I'm only saying I'm expecting this. I'm expecting this does not mean so and so. Okay, that is one case. One more, Harris versus Nickerson case. An auctioneer advertised in a newspaper that a sale of office furniture will be held on a particular day. You must have remembered in sale of goods, you must have studied auction sale. In auction sale, owner appoints a person called auctioneer. He is an agent. He releases an advertisement inviting bidders. Any advertisement that is given by auctioneer is not an offer, but because he's only inviting bids. So it doesn't show final willingness. And later on, even after giving advertisement, when all the bidders have come for a sale, if last minute, if he cancels the sale, nobody can file a suit on him. Nobody can file a suit on him. Understood. So that means in auction sale, whatever advertisement that is received, that is released by auctioneer is just what? An advertisement. It is just an information given. It is an invitation to offer. It is the buyer who has to make an offer to buy. Therefore, there is no final willingness. Since there is no final willingness, this is not amount to offer. So he is not held. He is not liable to sell the goods. That's it. One more case law you see. So these kind of tips you remember. Pharmaceutical Society of Great Britain versus Boots Cash Chemist. The goods were displayed. Display is there. So the goods displayed, advertisement given, brochure printed, prospectus given, timetable given, information given, casual information given, catalog printed, a hotel menu printed. All these things are just invitation to offer. It will not show final willingness. Since they don't show final willingness, it clearly means it's not an offer. When it's not an offer, even afterwards, if they cancel anything, you can't. That means a person who displayed the goods, if he's reluctant to sell the goods, you can't file a suit on him saying that why are you not selling, because you already displayed the goods. Because displayed goods in an exhibition or in a shop, offer should come from the buyer. Offer cannot come from the seller. Yes. It says goods were displayed in the shop for sale with the price tags attached on each article, and self-service system was there. One customer selected the goods, but the owner refused to sell. Obviously, he can refuse. In this case, it was held that display of goods along with price amounts to invitation to trade, and therefore, if an intending buyer is willing to purchase the goods at a price mentioned, he has to make an offer. And once you make an offer, does not mean I should accept it. No, being a person who displayed the goods, is it compulsory that I should accept the goods? Not necessary. Why is it's not compulsory for me to sell the goods? I displayed the goods. It's my wish, boss. You have to make an offer. You make an offer. If in case I'm interested, I will sell the goods. Otherwise, I will not sell the goods. Customer has no right to compel the seller to sell the goods. Are you learning something? Yes, very good. Yeah, that is one case law. Another case law, another concept, you have rules for valid offer. This is trade theory question 2, 2, 3, 2, 2, 3, 2, 3 lines and small examples. If you give yes, you can kill this question. What is that? What do you mean by offer? What are the legal rules for valid offer? So number one, every offer should create a legal relation, which means parties must be serious in taking action against each other. And every offer must be certain, must be definite. It should not be vague. It can be express or implied. It should be different from invitation to offer. It should be communicated. It may be conditional, but those conditions have to be made clear, and certain conditions should be reasonable. Understood? If in case you place a condition and it is not accepted, please don't presume that it is accepted. If I place a condition that is not accepted by the offeree, don't think that he has accepted. No, you cannot have a condition non-compliance of which amounts to acceptance. You cannot have a condition, and if it is not followed, don't presume that he has accepted. A makes a promise to B that I would like to marry, and he also says, if you don't reply within 3 days, 4th day onwards, you're going to be my wife. Nonsense. How can he say? If in case she did not reply within 3 days, you must understand that she is not interested. So you cannot place a condition, and if such condition is not followed, don't presume that it is already accepted. Got it. Now acceptance. What is acceptance? Giving a consent. It says person to whom the proposal is made signifies his assent. Understood? A proposal is said to be accepted when you give a consent or assent. Got it? One more thing, acceptance and offer. General rule, offer can be accepted only by the person. Acceptance rules. Obviously, when I make an offer to B should accept, not B's sister, right? If A wants to marry B and A made an offer to B, it is B who has to reply, not B's sister, B's mother. Unless that was already discussed at the time of contract. And specific offer is an offer which is given to a particular person, and such kind of offer has to be accepted by only such person. General offer is the offer which is given to entire public. Anybody can accept. Go by, this is just a revision material which is given. Go by ICA textbook in detail. You already have studied. Legal rules for valid acceptance. It should be absolute in the sense when you want to accept, you are not supposed to place any conditions. Whatever terms and conditions that were already placed by offerer, if you are interested in accepting them, accept, otherwise leave it. So offer should be without conditions. When offer is without conditions, we call it as unqualified acceptance. Then next one, just like offerer has to communicate offer to offeree, offeree also has to communicate his acceptance to offerer. Whereas here, there are two rules, communication of acceptance. If in case that is there, we'll discuss. Let's see. So it has to be communicated. Next one, sometimes offerer, when he made an offer, he would have given you a method or a mode in which you have to reply. You have to strictly follow that and reply. If you don't, then it is not valid. And sometimes offerer might give you a time, offerer might give you a place, offerer might give you a method, whatever mode prescribed, whatever date prescribed, whatever time prescribed, you're supposed to accept it. However, when you want to accept, you're not supposed to accept before, you're not supposed to accept after the lapse of offer. Lapse of offer is nothing but the end of the offer. Offer will be ended when the person who made an offer dies, or when the person who made an offer becomes insane, when the person who made an offer became unsound, when the person who made an offer becomes insolvent, when the person who made an offer already revoked the offer, any terms and conditions are not followed, any previous conditions are not followed, any method is not followed, any time is not followed. In such case, the offer will be lapsed. You are supposed to give an acceptance before offer lapses. That is that revision. Nice, Noyer. Nice. Next, there are a few cases here. Just a second. There are a few cases here. This case, you see, accept felt houses was Brindley. F offered by a letter to buy a nephew's horse, saying, if I hear no more about it, I shall consider the horse mine. Abba? He says, if I don't hear anything from you, I will think that horse is mine. Comedy, huh? The nephew did not reply, but he told an auctioneer not to sell that. So nephew mentally decided that it should be given to his uncle, but he did not reply. Means he did not communicate. Acceptance has to be communicated, but unfortunately, in this case, acceptance has never communicated. That means mental acceptance is not an acceptance. Silence is not an acceptance. That is the concept. But he told his auctioneer not to sell. But by mistake, auctioneer nicely sold the horse and his uncle filed a suit. Then court says he's not liable because he never communicated his acceptance. Simple point. Since he has never communicated acceptance, there is no contract entered between his uncle and nephew. All right? Yes. And Carlyle versus Corbally Company, you know. General offer may, communication specifically is not necessary. Finish, you know that. Next, Neil versus Merit. M offered to sell his land to N for 280 pounds. N replied, purporting to accept the offer. I mean, regarding the acceptance of offer, but enclosed a check for 80 only. M offered to sell his land to N for 280 pounds, but N replied saying that I'm accepting it, but he enclosed the check of 80 only. He promised to pay the balance of 200 pounds by monthly installments of sons. Understood? So it is not completely accepted. See, the N was held that N could not enforce his acceptance because it was not an unqualified one. And it was held that N could not enforce his acceptance because it's a qualified one. Condition was there. Okay, so go through that. And one more case law we have here, Brogden versus Metropolitan. It says Brogden supplier sent a draft agreement relating to the supply of coal to the manager of railway company. They are Metropolitan Railway for his accept. The manager wrote a word approved on the same and put the draft agreement in the drawer of the table. Awesome fellow. That means he received it, but he wrote even agreed, approved also, but he never communicated. So here also what is missing? Communication is missing. Since this has never been communicated, which means what has not been communicated? The acceptance has never been communicated, has never been communicated. There's no contract. And this institute, this reference material, whatever is there, if you want, I'll share it. All the BRIC students, let me know. If you don't know, I'll share it. This will help you a lot. This will help you a lot. All right. So this, I will record one more lecture. You just keep, if in case you are already very clear, don't waste your time in listening to these classes right now, just before 2-3 days. If in case you think you are feeling bored and you just wanted to have a grip of it, that patience you have to test yourself, right? You continue watching this. This will definitely help you last minute to remember something. All right, guys, I'll come back. And don't forget, one day before of economics exam, I'm giving you 200 questions to practice. I promise out of 100 BCK plus this one, 200 questions I'm going to give you early morning. I mean, morning time, 8 o'clock, between 8 o'clock to 9 o'clock, I'll release the question paper, take a printout and practice. I'm pretty sure that will help you to score 70 marks. Yes, provided you already had studied, you had some understanding. Other than BRIC students, if you still want to know, you please do call us. We will help you. BRICS Academy website, www.bricsacademy.com. You can find our contact number. You please call on this number. Otherwise, you can take down 951-333-267. I repeat, 951-333-267. You call on this number. We will WhatsApp you the question paper and you can write. All the very best. God bless you.